More like intermediate scrutiny, really.
Yeah.
Well, Your Honor, I don't think so in this case. We're simply saying you just have to substantiate what the government is saying. So if I can just give one example that I think proves what we're saying. The government said one reason for dismissing the case is that the relator promised that he would narrow his claims, and then he failed to do it. The relator cleared the precise amendment with the government before filing it with the court. The government signed off on the amended complaint. And then the government, after the fact, says you didn't do what we asked you to do, when in fact they did exactly what the government approved. So is that arbitrary? That sounds arbitrary to me, and under, I think, a strict...
Oh, sorry, finish.
No, I was saying under a strict, even just rationality standard.
You said before when I asked you what could the government do when it was in the suit, and you said could make a motion under Rule 41 like any other party, and this is if it chooses to proceed with the action. The standard there would be then the same?
Well, under Rule 41, it wouldn't apply here because, again, you have two plaintiffs. So,
No, I mean like if it chooses to proceed with the action during the initial sealing period.
Oh, I'm sorry. If it chooses to proceed with the action, then it can move to dismiss, and I presume it would invoke its C2A authority as opposed to Rule 41.
Okay.
I think the C2A authority here would probably displace Rule 41.
So there's no, I thought you had said something before about Rule 41. I must have misheard.
No,
I'm sorry.
I think what you might be referring to, Justice Barrett, is the fact that you said if the government intervenes later, then it can act under the federal rules of civil procedure as any normal party would. So why wouldn't Rule 41 then be available to the government at that point?
May I answer?
Sure.
I don't think it would be available precisely because of the nature of the act and its displacing of Rule 41. Now, what I was trying to say earlier, and I might have misspoke. If I did, I apologize, is that the government can invoke other rules of federal procedure. They can invoke Rule 12. They can invoke Rule 56. If they think the defendant is in fact right and that the case has no merit, they can say so, and that there's nothing wrong with that. That's not interfering with the relator's status and rights. What is interfering with the relator's status and rights is putting specific limitations from paragraph 2 on what the relator can do when the relator's been vested with the right to conduct the action.